In this lesson, we will continue our discussion on copyright law. In the previous lesson, we had a look at the different types of works that are protected and the elements or the characteristics that must be portrayed or distinguished from that which are not. First and foremost, much like the discussion we had previously, any idea, procedure, system, method of operation may not be protected under copyright law, even if it were expressed, illustrated, or embodied in a type of work. Any official text of the legislative, be it in any particular jurisdiction worldwide, may also not be protected. The news of the day, which is published or broadcasted and publicly communicated, does not fall within the ambit of protected works either. And as per Exxon Corporation and Exxon Insurance Consultants, simple works such as titles of books or short slogans, for instance, are also not protected. By and large, protected rights can be categorized into either economic rights or moral rights. On the one hand, economic rights enables the owner to derive financial benefits from the works that he or she has created. Conversely, moral rights are allotted or safeguards the honor and reputation of the owner. Our discussion from this point onwards will look at these two distinct types of rights in turn. Firstly, economic rights can be categorized as a series of acts that the owner or an authorized person for that matter can carry out where there is some sort of financial or an economic benefits that accrue to that owner or the authorized person respectively. Now, in essence, what this means is that any type of original work that has been created can be perhaps reproduced, sold, and so on. So let's look at each individual option that an owner or the rights holder of an economic rights in relation to a copyrighted work or protected work may have. On the one hand, he or she may be able to reproduce the work. And what is meant by reproduction is the making of one or more copies of a work, including any type of permanent or temporary storage of the work. A good illustration can be seen in Chandra and Emperor Air, where it was noted that a copy is one which is so near the original as to suggest the original to the mind of the concerned. Now, what must be noted here, or what's most important to recognize, is that the reproduction that we speak of here, or the copy of the original, can be only made under authority of the owner or the authorized person. Secondly, the public distribution in relation to the original types of work, which may derivatively have some sort of economic benefit, also relies on this doctrine of first sale. In essence, what is meant by the first sale is that the one who buys any lawful copy of the reproduction that we looked at a bit earlier is entitled to resell it free of any type of restraint by the owner of copyright. Now, while this is the general premise and while this is what is manifested on the face of many different types of sales, it is possible for the owner or the authorized person of the copyright to actually specify that no further resale is possible of a copied or reproduced good. A public display is also possible in relation to the owner or an authorized person. The showcasing or the showing of this original work or a reproduction or a copy of the work is also possible either directly by means of a film or a slideshow, etc. And in the case of audiovisual work, in a place where persons outside of the normal circle of the family are present. In essence, public display relates to, for example, if a person purchases a copy of a film, if it is being watched with the family, let's say the immediate family or close group of friends, that may not amount to a public display. However, when it goes beyond the ambit of that small circle of people, you owe a certain set of financial obligations or certain payments or rights which you are technically usurping from the original owner or the authorized person. Conversely, similar to the public display, you may have a scenario where performances are also manifested. This in turn may relate to things which are non-recorded, like audiovisual work. So in relation to non-audiovisual work, such as recitations, playing, dancing, acting or performing in public, as well as in relation to audiovisual work as well. In public in this context is considered in Harms and Martin's Club, where it was considered that what amounts to public depends on the facts and the circumstances of any particular case. Now, a bit earlier, we noted that the public display of any particular audiovisual work may mean something which is beyond your family or close group of friends. So anything which is being showcased to outsiders amounts to the public. Similarly, in Harms as well, that is what has been noted by their lordships. Gavia Plastics and Telelink has tried to extend this notion and tried to elaborate the criteria which may be considered when discussing if something amounts to being a public performance or not. So for instance, the character of the audience, just like we looked at a bit earlier, if it goes beyond simply family or friends. The relationship between the audience and the owner of the copyright, as well as the effect on the copyright's economic interest. So for instance, if you as the person who has now purchased a reproduction of the original and you're charging admission to showcase it, to show it the performance or any type of display, then that in turn may indicate that you owe a certain amount of consideration or payment or economic benefit for the original owner. There are a few notable cases which outline how exactly we are to look at these criteria. Just like what I mentioned a bit earlier, Performing Rights Society and the Hawthorne's Hotel had noted that an audience need not be a paying audience, although that is a good indication that economic rights may entail for the original owner. Moreover, even switching on a radio in a public place, for instance, amounts to the public performance. Basically, the idea being that if it is being heard or if it is being enjoyed by a group of people not amounting to the family or close circle of friends, it may in turn be liable for costs or liable for payment for the original owner. There are certain other types of communications to the public as well, where the owner might stipulate that in these situations or in these instances, there must be a separate payment that is made. Thanks a lot for watching this video. Click on a subject of interest to learn more.